Contempt application arising
Filed
out
a
of the,
contempt application?
I have already filed, Lordship.
Okay, then you give the slip.
My lord, may I be permitted
Obliged.
to mention a matter from the PLA division, my lord, for inclusion in the list?
Yes.
Obliged.
It's original slip to. রেখে দিন আর কি। কল করতে হবে এখন 10:45 হয়ে গেছে তো রেখে দিন দেখুন না
Item number 1.
Your Lordship, in item number 1, I am for one of the trustees of a trust, namely as Chimanlal Bhartiya Trust. This matter was taken up by Your Lordship on 20th of May, Your Lordship. The papers which have come before Your Lordship, that is of PLA 102A of 1993, but it is wrongly appearing as 102 of 1993. That's why on the last occasion, by an order of 20th May, you have called upon the register original site to submit a report as to why the PLA 102 of 1993 is not registered. Your Lordship, that report is yet supposed to come before Your Lordship because it has to be numbered. This last order. Last order দিয়ে রিপোর্ট দেয়নি এখনো
Okay, report
The
has
cost
not yet
settle is correct. The cost settle, whatever
report has not yet come.
Your Lordship, there was a direction on 20th of May, Your Lordship.
Yes. So let a date be fixed for furnishing the report. Yes. In terms of the order dated 20th May 2025, a report was directed to be submitted by the registrar original site. But till today the report is not yet submitted. Let this matter appear on এসছে report. ঠিক আছে দেখে নিচ্ছি Yes, registrar has sought some time to submit further report after detailed inquiry.
In the meantime, what I was, Lordship, I was submitting that I filed the Wakalatnama within the time as was specified by your Lordship. May I apply for the certified copy of the entire cause paper so that it can be given in the meantime? Let the report comes before your Lordship by the
Yes,
registrar.
record an order. You are for
I am
applicant?
for one of the trustee of a trust, your Lordship.
Okay, learned advocate for the trustees of a trust is present. Peruse the report submitted by the registrar original site. The registrar has further sought time to submit a detailed report as to what is the new number of PLA 102A of 1993. Thus, a fresh report may be submitted after inquiry. Let this matter appear on 4/7/2025 for submission of report. As prayed for by learned advocate, certified copies may be applied for.
Deeply obliged.
Number 2. My lord, I have applied for certified copy of the print. I am the plaintiff in this matter, my lord. So certified copy has not been provided to me because the copy of the plaint in the record has not been taken on record in the files. The department has informed me so. So a deduction may be given for giving me a certified copy, which has been already been applied for of the plaint.
My lord, I appear for the defendant number 1.
I have given them notice also.
You are for?
For the defendant number 1, my lord.
I am the plaintiff. I have given notice to the defendants also so that there is no confusion.
Certified copy.
Now, actually, the registrar has sought for permission to reconstruct the plaint.
Yes, Your Honor. It is already plaint is already there on the record.
No, but it is stated that from the plaint, it cannot be, it does not have any proper court fees affixed to it.
Your Honor, the original plaint must have, otherwise the
So
suit
it is
has not.
stated the original plaint does not have proper court fees affixed on it.
Your Honor.
Anyway,
So
let further
we-
inquiry be made whether the plaint lying in the department is the original plaint or not.
it is there. I have taken inspection of the record. I have seen it. The court fee is not stamped. Court fee is not because it is a copy of the plaint. The original copy of the plaint is not there in the record.
Yes, that is what it stated.
Yes, Your Honor. So
is
I am
what is-
so I am seeking that let that be regularized by taking that.
Yes.
I have given a notice for that purpose and to the defendants
Learned
also.
advocate for the plaintiff and learned advocate for the defendant are present. The report submitted by the registrar original site is taken up for consideration. It is stated that on scrutiny, the plaint in question in EOS number 2 of 2007 appears to be copy of the original plaint as it does not have any proper court fees affixed on it. Stop. As the original copy could not be traced out, let the records be reconstructed in accordance with the rules.
My lord, one more prayer, Your Honor. This matter has already been compromised. So I want to file.
Let it be reconstructed. Thereafter, you file necessary petitions. Okay.
Your terms of compromise, if Your Honor allows, then I will file that compromise petition in the department. In the department, it will be taken up later, no problem.
Okay. The terms of settlement may be filed in the department.
Yes, Your Honor. Yes.
Obligement.
4th of July. Yes, it will appear 4th of July.
Much obliged, Your Honor. Much obliged.
Item number 3 and 4.
Your Lordship, I'm for the petitioner in
I'm
both
appearing
GA.
for the
3,
executive.
you are appearing.
Yes, 3 and 4. It's two GAs. GA number 3 and GA number 4. I'm the petitioner in both of them. Your Lordship, GA number 3 is for
This
appointment
is
of,
your application.
yes, both the GAs. One is for appointment of administrator pendent light, Your Lordship. Today I'm filing the affidavit in reply in that GA. It has already been served on my learned friend. And GA number 4, Your Lordship, they were supposed to file their affidavit in opposition.
GA3.
Lordship, we have prepared
Petition
the
time.
affidavit in opposition. Dara, बोलेंगे.
GA3. Okay, GA3 records are not here. Okay. So let this matter appear next Friday. Yes, record an order.
Your Lordship, if I can be granted time for the meanwhile to file my affidavit in opposition, it is ready. It
GA4,
is GA4, it is
Learned
ready.
advocates, দুটো ম্যাটারই একই আচ্ছা GA3 তে আগে লিখুন learned advocates for the parties are present as the records of GA3 of 2024 is not here in court. The matter stands adjourned till 20th of June 2025 for hearing of this application. Let these records be put up.
Your Lordship, but I have
Then-
filed the affidavit in reply.
Yes, let the affidavit in reply file be kept with the record. Acha, next, GA4. Learned advocates for the parties are present. As affidavit in opposition is not yet filed in GA4 of 2024, let affidavit in opposition be filed. Yes, it will take some time, GA4. It cannot be on the next Friday.
Fine, my lord. Because we have to file the affidavit in
Yes.
reply.
Let affidavit in opposition be filed by 20th of June 2025. Reply, if any, by 25th June 2025. Let this matter appear on 27/6/2025.
Your Lordship.
Item number 5.
My Lord, may kindly recall, this is that matter where we have sought for modification of
Oh,
the decree.
right,
Yes, ma'am.
partition.
Yes, ma'am.
Anyway, let this matter be heard out and necessary orders has to be passed. Okay, give this. Okay, so you have sought for review and modification. That
Review and
ultimately,
modification to the extent that though the partition commissioner's report, which forms a part of the final decree, speaks about sale of the concerned premises, but the final decree is conspicuously silent about the steps in pursuant to that portion of the partition commissioner
although
pursuant
the
to say.
commissioner's report
Yes,
says
ma'am.
it is an impartable
Yes,
estate.
No, yes, it is. It cannot be partitioned amongst the co-sharers, and the co-sharers were ad idem so far as the sale of the property is concerned.
Entire property or only a
Entire
portion?
property, madam. The entire property.
So
My lord,
this
I
is
have
your
taken-
petition.
Yes, this is my petition.
No opposition filed.
No, my lord, there is no question of opposition being filed.
This-
The defendants were served. They are not before your lordship. My lord, and what we are seeking, my lord, in any event, all the parties have shown, my lord, that they are ad idem so far as the sale of the concerned property is concerned, considering the fact that the property is impartable and at present it is in complete dilapidated condition.
Anyway, some commissioner has to be appointed.
My lord, yes, my lord, everything done. Partition commissioner has appointed a valuer who has visited the property. He has submitted a report stating that the property is in entire shambles. He has also valued the property. Parties have accepted the valuation. Parties have also, they are on ad idem as to their own shares that they would get in the event the property is sold for that consideration. Everything settled, my lord. Now what has happened, my lord? The plaintiff wants to purchase the other co-sharers, and since the prices fixed by the partition commission. I have shown, my lord. And it has also been recorded in the partition commissioner's report that all the co-sharers are ad idem so far as sale of the property is concerned. My lord, now retaining this property or considering again partition will be a redundant affair, my lord. And so the plaintiff has come forward and he has evinced a desire to seek an order that a sale be.
So defendant number 1, what have you prayed?
My lord, defendant only, my lord, I'll show, my lord, kindly have a look.
So motion ta din to eta.
My lord, kindly have a look at page 41. It's a part of the commissioner's report.
41.
কি বলছেন? Para 9, my lord, may kindly consider at page 41. It's a part of the commissioner's report.
So, inner page.
My lord, I have seen, in view of the fact that none of the parties have any objection to valuation report filed by the valuer, I, as commissioner of partition, accepted the valuer report.
Para 10.
Para 9, my lord.
Para 9.
Page 41,
Yes.
internal page 6.
Yes.
In view of the fact that none of the parties have any objection to the valuation report filed by the valuer, I, as commissioner of the partition, accepted the valuation report and accepted the valuation of the property to be rupees 1,07 lakhs, which if sold, the individual parties according to the admitted share would receive the amount as shown herein below. Well, thereafter, the shares of the parties and the amount that each would be entitled to have been given in the tabulated sheet. Thereafter, kindly consider paragraph 10. In view of the fact that most of the parties were ad idem with regard to sale of the said property, that there has been no issue with regard to challenging the valuation report in any manner whatsoever. The instant report of the commissioner of partition is being filed accepting the valuer's report and indicating the amount that would fetch upon the property being sold according to the valuation report. Now, paragraph 11 is most important. In view thereof, the instant report is being filed pursuant to the order dated 21st November 2019 for the Honorable Court to pass further order for sale. Kindly marks this word. Further order for sale for further steps which would be necessary in the instant matter. Now, kindly, my lord, considers the final decree that has been passed. That is at page 80 of Lordship's brief. My lord, the operative portion is at page 82. Kindly have a look at the third para onwards, my lord. May I please? This is a final decree. It appears that this court, by order dated 30th August 2019, decreed the suit being CS number 289 of 2014 in preliminary form. By that order, the parties were allowed 3 months' time to effect partition mutually from the date of the decree. In default, the plaintiff or any of the parties to the suit would be at liberty to put the decree in execution to get the suit decreed in final form by adopting the commissioner of partition. Since the parties failed to effect partition mutually, Mr. Such and Such was appointed as the commissioner of partition. I have perused the report of the learned commissioner of partition. Since there is no objection to the report of the learned commissioner of partition, the report prepared by him may be accepted. Accordingly, the report of the learned commissioner of partition is accepted. Now, the most important part, my lord, the suit is decreed in final form. In terms of the report of the learned commissioner of partition, the report of the learned commissioner of partition do form a part of the decree. My lord, therefore, the learned commissioner's report has been accepted in toto by this honorable court, my lord, while passing the final decree. Yet, my lord, this decree is conspicuously silent so far as the sale of the property is concerned. My lord, if may I read further, my lord. As directed by this court, by the order dated 21st November 2019, the plaintiff is entitled to reimbursement of all the expenses made by him towards fees of the commissioner of partition and valuer, which the plaintiff had to pay in excess of his 1/6 share. If so advised, the plaintiff is at liberty to take appropriate steps in this regard. An amount of such and such has already been paid by the plaintiff to the learned commissioner of partition as his initial remuneration. The plaintiff is directed to pay a further amount of rupees such and such to the learned commissioner of partition towards payment of his final fees. The decree be drawn up accordingly. And the only grievance that we have, my lord, in spite of accepting the commissioner's report in toto,
So that is silent with regard.
yes, my lord, that is the only clarification we seek, my lord.
So you are seeking a review of this
Review,
order.
my lord, only to that extent that the decree may read that the that sale of the property be effected.
Sale has to be by the commissioner or by appointing a receiver or special officer.
My lord, that in the event the defendant do not execute the deed, my lord, that is my second prayer. If may kindly have a look at the master summons, my lord. Okay. My lord, kindly have a look at page 11, my lord. Page 11,
I'm taking this prayer B.
prayer B is
In
there.
case of failure of the part of the defendants in executing law and register.
This is the alternative prayer that we have. First, a deduction has to be passed, my lord, for effecting sale. If it is not complied with, my lord, in that event, my lord, now the defendants have all been put to notice about pendency of this, not once, but several times. The court, upon being satisfied that the defendants have voluntarily chosen not to appear before your lordship, has fixed this matter. My lord, now, in that event, my lord, kindly pass an order in terms of prayer B, my lord. There is no dispute as to the valuation of the property and the entitlement of the parties to the respective shares and shares converted into monetary
You are
terms.
representing the plaintiff.
My lord, for the plaintiff, my lord.
Yes. Learned advocate for the plaintiff is present. None appears for the defendants in spite of service of notice. The application DA5 of 2023 is taken up for consideration. Heard learned advocate for the plaintiff, peruse the petition filed. The hearing is concluded. Let this matter appear on 28th of June 2025 for orders. Affidavit of service already filed.
Yes, well, on the last occasion, I have filed affidavit of service. My lord was satisfied about the defendants being served.
20 তারিখে for orders.
For orders 20. My lord is keeping the matter on 28.
20. আগে তিনি করে দিয়েছেন। Let the আরেকটা order লিখুন, let the affidavit of service filed be kept with the record.
My lord, it was that
So it was
order
there
is to
earlier?
that. Yes, my lord. It's
Okay, okay.
Action motion, item number 6.
May I appear for the petitioner, my lord?
এটা রেখে দিন।
My lord's last order of 15th of May, there was a direction on the registrar to produce the records of 2 old general applications, which has come, I believe, yes. Now, 15th of May order, these orders and the petitions were not with us.
15th of May.
Lordship was hearing GA 9 of
Yes, GA9.
2024, yes. Now, the 4th paragraph of the order records that it appears from the petition
Yes.
that the relevant orders passed in GA number 1998, 1999 and not annexed. The petition nor is available in the record. Thus, the registrar was directed to produce the records. This was necessary.
Directed to appear today.
Yes. And I think the papers have come. The papers have come. The reason of these papers to be brought before the court, my lord, is this. Lordship, in the petition, Lordship, in the petition that we have served I am the defendant in the suit.
Yes, on the last occasion, receiver was here.
Yes, receiver was there. Yes, that matter. Receiver was there.
Yes,
He has
Mr.
filed a
Dosu was
report
there.
also. Yes. He has filed a report. There's sum of more than 1 crore in the bank with Standard Chartered, whatever, 5 crores. Oh, 5 crores with the Standard Chartered Bank. And I say I am the defendant in the suit of Rashtriya Ishpat Nigam Limited. That the plaintiff's claim is satisfied. Plaintiff is no more interested in the suit. This money is
Any
for,
order is passed in the suit that the plaintiff is not interested or the suit be disposed.
in that order I cannot seek because I am a defendant in the suit. I am only seeking to the extent this money be released to me because the suit is
Lying with the receiver.
yes, the money is lying with the receiver. So in the midst of the hearing, the records of these 2 general applications were required. I'll tell you, Lordship, why this was required. It's my lord's pleasure to come to my pleading at page 6 of the application.
Yes.
I've given a bit of the story, the reason of filing this suit. This was a advanced license. My lord will
Okay,
kindly
4524. That
Yes.
is for
4524 is the order which the defendant has filed for vacating or setting aside other two injunction
The other
orders.
GA 4059,
One is 4524 and the other was in the
4059.
4059. Yes, 4059 টা হচ্ছে ওই এটা. Is the parent, is the first application by the plaintiff where the injunction was sought for.
So that was made absolute. Or that is.
No, then the vacating, I moved the vacating,
Yes.
that was vacated, and then the liberty was given to sell the advance license.
So let me see that order also.
Yes, those orders must be there in the, that is the reason. For us, it's
Those
impossible to
orders-
have
Those
access.
orders, anyway, it can be considered, or if you can also file some additional supplementary.
Yes,
affidavit
that I
also.
can. What I can do, Malad, I can see the position of the records.
That also you can take some time.
Yes.
You can come with a supplementary.
Yes,
affidavit.
and I can, if I take an inspection of this
Yes, yes, yes.
or a certified copy, এতটা এত certified copy কি করবে এমনি? I can take an inspection
I
of
can
this.
give you 2 weeks time.
Yes, well, kindly. Inspection, and in the event I require, I can obtain a certified copy, because if I want to file a supplementary affidavit, certified copy won't be available. It will be so fragile, the papers. I'll take inspection in my lord's court only. I'll come and
Yes.
look into the papers. Because I
Mr.
can't.
Mitro, learned advocate for the defendant, petitioner is present. None appears for the plaintiff. The copies of GA 4059 of 1998 and GA 4524 of 1999 are put up. Stop. Mr. Mitro, praised for taking inspection of the record and file a supplementary affidavit to this application. Such prayer is allowed. Let this matter appear on 27/6/2025 under the heading adjourn motion.
27 রাখছি তো বলো oh they will, I think they, well, can
Yes.
we come back on 25th or 26th any day? 25th or 20th, but 27th is likely a holiday. Holiday will be declared 27th.
I can do one thing. If you
25th or 26th,
can, want,
or I'll take inspection today or tomorrow only before
25/6/2025.
25 তোমার তো অফিসে 30 তারিখে কি আছে? হ্যাঁ ঠিক আছে, ঈদ কি যেটা হবে ওরা ডিক্লেয়ার হবে অবলাই
Item number 7.
দেখি রেকর্ডটা এটা অর্ডারটা লাস্ট অর্ডারটা Yes, record an order. None appears for the parties when the matter is called. It further appears that on May 20, 2025, the matter was called, but none appeared. Stop. However, in the interest of justice, the matter be fixed on 27/6/2025 as the last chance.
Item number 8.
Item 8, yes.
Yes, my lord. Item number
But
8.
for
Plaintiff, my lord. I'm led by Mr. Nilotpal Chatterjee, my lord. Item number 8 and
all the 3 matters.
No, my lord.
No,
Item number
both the matters.
item number 8 and 9, my lord.
Yes.
My lord, in this matter, your lordship has last time requested us to serve copies to the other side, my lord. But in the meantime, my lord, this is a change brief, my lord, and we have some records missing.
Anyway, I'm
Lord-
granting you time to
Yes,
take the necessary steps. You say
in
1979
case,
suit.
yes, my lord, a very old suit, my lord. This is why, my lord, in case we, if necessary, my lord, we will apply for
Yes.
certified copies, my lord.
Anyway, whatever it is, you take necessary instructions.
Well,
Learned
some-
advocate for the plaintiff and learned advocate for the defendant number 1 and 2 are present. Learned advocate for the plaintiff prays for time to take necessary instruction
Yes.
and collect necessary documents.
Yes, my lord. And
The matter stands adjourned till 4th of July, 4th, 7.
Some more time, my lord, may be needed, my lord, because we have to
Okay,
go through everything, my lord, very all many
okay,
documents.
11, 7.
11,
4 weeks you are getting? 11th of July.
maybe in sometime in August, my lord, sometime.
Okay. On 1/8/2025,
Grateful, my lord.
1st of August.
First of all.
Both the matters, 8 and 9.
8 and 9, my lord.
8 and 9,
Significant
দুটোতে
kind of
একই order.
matters, my lord.
Whatever it is, you take instructions from your clients.
I am ready. They are not ready.
No, I am keeping it in the month of August, 1st August.
Yes, my lord.
1st August, Friday.
Item number 10.
My lord, I beg to appear. Lord, I appear for the other applicant, my lord, proposed. Possibly, I am the answering respondent today, my lord. I am appearing on behalf of the receiver. There is a direction of your lordship on the last occasion, 21st May 2025. My lord, before going into the, my lord, the
Yes, I have
Yes, your
directed
lordship may
the
recall.
receiver to hold discussions between the
Correct.
parties.
Absolutely, my lord. Accordingly,
So, on the basis of the receiver's report, or
Right.
I shall pass necessary orders
My
or fix the matter.
my lord.
But I had appeared in that meeting.
Yes, what is the report?
This is the report, my lord. May I be permitted to indicate two things, my lord?
Yes.
My lord, there is 2 GA has been filed from the different parties. They are the my lord outsider intending purchaser. They have forwarded their offer. Now, their different offer is that one is 70 lakhs and one is 65 lakhs, subject to the negotiation of a property as it is where it is basis.
Yes.
Now, this property is occupied by the different tenants, incumbent property. Now, in the meantime, one of the co-sharer, Mr. Ajit Kumar Rai, objected to this GO by filing a objections by saying that I am also willing to purchase the property subject to the clearance of the incumbents. That means he wanted to purchase the land on a freehold basis, and that too in a 65 lakhs. But there is no separate GA has been filed before your lordship today. That prayer, if he has come up, he has to be come up in a proper application.
Yes.
This application is not sustainable. And more so, as per this direction of your lordship, we have hold the meeting on the last occasion. I have indicated, we have given the circulated the notice. Mr. Rai
What
has
is the outcome of the meeting? What is
meeting,
your
yes, I just indicate. I will not take much
you
time.
held discussion? What did the parties resolve?
Parties has come to a 2 possibilities that this can be resolved by the court by giving a open court bid, and also
Page 4, my lord, of the
Yes.
page 4 of the.
Open court bidding and its alternative by giving a quotation.
I declared one of the interested parties, but I have given the option number 1. I'm sorry, option number 1.
So, if there is a bidding, you can participate.
yes, of course.
Yes.
That you can do.
Of course.
Whoever has made the offer, they will be
They
free to
will be-
participate.
everybody will be.
So, if there is a bidding, open bidding, the intending purchasers can participate.
Of course, of course.
My lord, I am defendant number 11. I am appearing in person. I am Ajit Kumar Roy. I could not be present in the meeting. I had informed the learned receiver much in advance. In spite of
Anyway,
that,
so the defendant's suggestion is he wants to purchase by evicting the tenants. But anyway, whatever is not feasible, that cannot be done. Whatever is feasible,
Right.
whoever is intending to purchase as is and where is and whatever is the basis, that has to be given option. So you have recorded that the defendant has intended to purchase.
He was not present. He has circulated a WhatsApp message by saying that kindly adjourn the meeting. I shall not be present in the meeting. I have indicated in my report as well the report. He said that he won't be available.
I have
So
informed by speed post.
So you are willing to take it, provided the tenants are evicted. You are willing to take it.
There are no tenants.
What
The
is this?
honorable court
How
has
much price are you willing to give? How much
60
price?
63 lakhs.
Yes, are you agreeable?
No,
My lord, I have already made a higher offer, my lord, which is also negotiable.
So it's not a bid.
So
Yeah,
you are willing to purchase by 63 lakhs.
Yes.
So all of you are not agreeable.
My lord,
The
Very well.
valuation-
So
the
very well, no question. Whatever you want to do, let there be an open
My lord. Yes,
public
yes.
meet. You give your suggestion
Your
there.
Honor, the valuation was done by the honorable court of
But some
Justice-
reserve valuation report is there.
Yes, yes,
May
it
I
was
just
done by the
interject?
court.
Mr.
And
Rai,
it
this is
was
not the
accept-
way.
Let
This is
the
High
let
Court.
the
Please,
receiver submit.
It
Please.
was accepted by the
please.
court and
Let
subsequent.
him submit. You please be silent for the time being.
Yes. We have, in fact, pursuant to the earlier order, submitted the valuation report. Valuation report is in the record, but I just frankly indicate, the valuation has been measured on the basis of a surmises and the presumption that there is no
Oh,
income.
whether the sale will proceed as per the valuation report. So a fresh valuation has to be done. Yes.
Valuation blood has to give blood which can be considered as a base blood. Whoever bids the highest.
This is I just indicate the difficulties. I am not objecting because I am the officer of the court. I am the receiver. I am not objecting anyway. I am just proposing what is the difficulty. Difficulty is that whatever the valuation has been done and the calculation on the basis of there is the no income. So naturally, my lord, when the matter will come into before your lordship, it will be considered whether what is the nature of the property. As per my knowledge, since I am in the possession of the property, I said there are number of tenants are there. It's an occupied place, and it is not possible for the receiver even to evict each and everyone and give a the vacant portion of the property.
No, valuation report was furnished. Okay.
I have furnished.
So any exception taken to the valuation report?
There is
No exception. So upon valuing the property by a registered valuer, you have submitted the report.
Mine.
That is the receiver has submitted.
Yes.
Receiver or partition commissioner.
I am receiver. I am the receiver. But she is the receiver. I am representing her.
There are more than 20 tenants. 20
Okay, so valuation report is submitted. Now,
Fine. Yes.
according to your meeting, as per the meeting, this is
The
okay.
proposal of the parties I have been forwarded before your lordship at page 4.
So it is there, and today your defendant number
11.
11. I have to record his submission also that he is ready and willing to purchase with the consideration money of
63 lakhs.
63 lakhs. Very well.
Subject to the eviction of the tenants.
No, he is telling there are no tenants. I shall record that.
Very well.
But I am the
Does it-
plaintiffs. I said that there are more than 20 tenants.
The property,
Whatever it is, he is ready and willing. He is unconditional offer that
yes,
63 lakhs you want to give.
yes, the valuation was arrived at by the honorable court.
Very well. 63 lakhs you are willing to give.
Yes.
Now the question is whether the other parties are agreeable or not.
No, who are the, we wish to know who are the parties.
No, the other
No.
plaintiff defendants.
No,
It
this is a family partition suit.
Whatever it is,
Yes.
there are co-sharers. If other parties do not agree, the court cannot pass the order. It has to go by auction.
Their other co-sharers are not present. They are not interested in this matter.
I have a purchaser who is willing to purchase. I'm
No.
saying
You are for
that
the, you are also a co-sharer.
No, I just have a question.
plaintiff is a co-sharer, partition.
So why are you
I-
saying co-sharers are not present?
May I just indicate
I
only one
want to-
thing? Kindly see the conduct of the Mr. Rai at page 2 of my report. Kindly consider this aspect. See the conduct, Millard.
That he wouldn't be available till June, hence he is to notify alternate dates of meeting. Anyway, even if you hold the meeting, he will say that he is ready and willing to purchase the
and
property at 60 lakhs.
63
60.
lakhs, yes.
63 lakhs.
63 lakhs.
Lakhs.
Very well. That will be recorded.
There is another point that I have not received the affidavit of defendant 7B.
Now, Lord, it's too late.
On
in
the
to
date-
say, my Lord. I think, Lord, on minimum 10 occasions, my Lord, this gentleman has come and Lord raised something or the other. Today, at this stage, my Lord, when the court is, my Lord,
Okay, what was the prayer made in GA today?
G11, my Lord. GA11 is my application.
What have you prayed for?
I have,
19 of 22.
Lord, I have prayed that in terms of the order, my Lord, I have an intending purchaser who is ready and willing to purchase the entire premises. my Lord.
So your application has to be considered along with the report.
GA19.
There are
I
two
have-
GA. There are two GA has been filed before your lordship.
Kindly see, my lord, 19 of 2024 is my application.
But
GA9.
in spite of the court order,
Again, GA19.
in spite of the court,
GA19.
Of 2024 is my lord, my application.
You are representing an intending purchaser.
Intending purchaser. But I have made an offer, which is also negotiable.
What offer you made?
But I have already made an offer of 70 lakhs plus my lord subject to negotiate. And my lord, as is
70
where is basis.
Okay, 70 lakhs. You are present in the meeting.
Yes, he was present.
And so far your client is concerned.
Lord, we are proposing 81 lakhs. On an as is, where is, whatever.
Hey.
there
My lord,
is.
70 lakhs is subject to my lord, the negotiation. That also my lord, we have indicated.
Kaguz.
Now, Lord, we speak it.
since I was not present in the meeting,
You have chooses not to present in the meeting, Mr. Roy.
We all will have the word.
since I was not present in the meeting, I would like to pray for another day.
No. What is your proposal? That is to be considered. You may not be present in the meeting. You are ready and willing to purchase it with 63 lakhs.
Yes.
Very well. That will be recorded.
My lord, my
The others are not agreeable.
My bid is
No, but
open.
this valuation was arrived at by the court.
Maybe,
order of the
maybe.
court.
That valuation.
Maybe.
Lord, just to add, my Lord, I had filed the application which is prior in time, that is GA11. Subsequently, my Lord, my learned friend has filed an application GA19. Now, my Lord, today, my Lord, we too are present before this honorable court, my Lord, seeking permission to deal, my Lord, or to, my Lord, purchase with the state. My Lord, our
GA19 of
applications are-
2000. You are for 7B, defendant number.
My lord, my lord.
So, my Lord, our applications are to be considered, my Lord, first. So far as Mr. Rai is concerned, he hasn't filed.
But
the
how
application.
outside the parties,
First or second doesn't arise, my lord.
this is the family partition suit,
My lord, we have
how
made an
these other
offer.
parties are coming into the picture.
Co-sharer, I can very well come.
No, you're a co-sharer, but you are bringing in outside the parties.
Anyway, commissioner,
Lord, we'll kindly
receivers report that it is an impartible estate that is there.
Yes, it is there.
That is there. So no other alternative.
There's
Yes.
no doubt.
Alternative. So sale has to be made. So far the valuation is concerned. So any exception taken to the
No,
valuation?
nothing. Milady, I just indicate one thing. So
No,
for
valuation can be kept as a reserve price.
milady, valuation, I tell you, lordship, the difficulty, the valuation which has been calculated on the basis of surmises that this entire property is free from encumbrance, vacant. That is the usually done,
No, the valuation is made by the valuer
made by the
and,
valuer,
endorsed by you.
endorsed by me, and it is on the part of the record as well, my lord. I will not trouble your lordship today, my lord. I understand, my lord. I will not trouble. Lordship may record whatever the, my lord, the outcome of the meetings today. What I am proposing, my lord. My lord, so far the condition of the suit property at condition, it is not, cannot be come to a logical conclusion apart from the sale. So, my lord, whatever the, my lord, the parties are before your lordship may consider the offer.
Anyway, I do one thing. It's
Yes, my lord.
better you give the defendant number 7B, that is Mr. Rai, one copy.
No, he's not selling.
He is
No,
the
My
seventh.
lord, the intending for.
Yes, you are which defendant?
11.
Okay, 11. Give him one copy.
Of-
It's better. No, copy of this GA application.
No, he has.
Now question is, then better you come, all of you come with your written notes of arguments and suggestions. Okay,
Very
let me pass necessary.
Suggestion rather. He cannot, he is the intending purchaser. Second. He is the intending purchaser. He cannot forward the written notes of argument. The proposal. It
Yes.
can be in the form
All
of
of
the
you
proposal.
submit your written proposals along with you.
Mal.
Okay, your meeting notes are there.
Yes.
All of you submit written notes of proposals, and with regard to valuation, if you have anything to submit regarding valuation, your submission will be taken into
Everything would be coming to
regarding valuation as well as written proposal. I'm keeping this matter on Wednesday.
Not just one aspect. We take to the other input. This is the report, my lord, filed by the learned receiver. my lord. In terms of, my lord, the order, my lord, I think now.
কোনটা? না, কোন রিপোর্টটা?
Your lordship may kindly see at the bottom I have underlined. That valuation, your lordship, is not for the time referring to, but that figure, as rightly submitted by the receiver, refers to the figure given by the Kolkata Municipal Corporation's website on a vacant piece of land. But this premises is fully occupied.
How old is this thing land? You know, land is
Land
more than 150 years.
Yes, this is something.
Of 1980.
Very old building. Building has.
Prior to me, our
Oh, you see,
independence
even if you make some public auction, there has to be a reserve price.
has to be, Milord. This is
So
the.
either this one or what reserve.
May I suggest one thing,
Yes.
Milord? Subject to the availability and the other approval of your lordship, Milord, there a fresh report may be come into the consideration before your lordship, before coming into the any conclusion that what would be the, Milord, the reserve price of valuer or otherwise has to be appointed. Otherwise, this is true.
Your Honor, the valuer had been appointed by the honorable court. If the valuer is the impaneled,
So better you come with a suggestion.
Suggestion.
So,
That's better.
as because there are purchaser above the price who are intending to buy with more price. So these valuations may be
Can be
modified.
considered, Milord, at the time of.
my lord, they should have placed their objections in the year 2015 and 16. They were silent all along.
Now the
Now-
question is this, both the GA applications are to be disposed of along with your, all the suggestions by you. Okay.
Right.
Suggestions by you, as well as you file your written notes of arguments also on your application.
Not necessary.
Okay, give your suggestion.
Suggestion.
Suggestions regarding the valuation.
And Milord, the proposed, Milord, the order and what is to be
Proposal.
done. Yes. I will also, Milord, consider and I will come
Lord,
back.
we will come back with the proposal.
Yes, yes.
Proposal, my lord.
Everybody should
Yes.
come, my lord, and the
With the that would be rather wiser,
Because
Milord.
ultimately, you see, even the intending purchasers can also participate in the auction.
Yes,
that
of
is
course,
open.
Milord, of course. There is no bar.
Yes,
It's an open option.
and my lord,
That
in
is
this
where
matter
the-
itself,
No,
my lord,
but,
previously that was done.
why
in
should this,
2014,
why should this
regarding another part
matter,
of the property.
Rightly
why
said,
should this
it's not the
matter
first time.
go out of the family?
You better consult an advocate. The advocate will give you the opinion. Okay. I am hearing the matter. Why the matter will go outside the family? It is not for the court to decide and give you the opinion. You take the consultancy from a lawyer. You will know the position of law
And he cannot question the
before
court as
making
well.
the submissions.
Previously,
Milord is the only person who is disputing.
previously 3 crore properties have been sold by auction.
Earlier.
And every occasion,
Okay,
Mr. Rai has
yes,
come up and
yes,
objected.
Your Lordship, kindly
That-
records, I am serving the copy of the application.
Yes. Please
Won't
take the
it?
copy.
Your Honor, that was a different matter. What
And my lord, he's
the learned advocate is saying,
there are no
You see, unless you engage an advocate, there will be no solution. You will make all these unnecessary submissions. Nothing, no fruitful purpose will be served.
no, but we had already proceeded as per the court's
No, you have
direction.
not proceeded. You are totally confused. Learned advocate for the plaintiff, plaintiffs, learned advocate for defendant number
7B.
7B, learned advocate for the receiver, and defendant number 11, Mr. Rai, in person, are all present in court.
Including the receiver.
Yes, learned advocate for the, you give your name also.
My lord, I have given. My lord,
Learned advocate for the intending purchaser also makes a submission in this case.
Receiver is also present.
Yes, I have recorded learned advocate for the receiver.
তো দাও, order-টা দিতে দাও।
Learned receiver has submitted the minutes of the meeting dated 21/5/2025 held at 4:30 p.m. in terms of earlier order passed by this court. Upon perusing the minutes of the meeting and upon hearing the learned advocates, this court is of the view that the parties should come with necessary suggestions with regard to the valuation as well as with regard to the mode of sale on the next date fixed. Let this matter appear on 25/6. আচ্ছা 25 তারিখে ওই 4টের সময় কোনো ইয়ে আছে ম্যাটার ফিক্স আছে দেখুন তো 25 তারিখে 25 তারিখে 3 PM রয়েছে ও 4টের সময় কোনো ম্যাটার নেই আচ্ছা 26 তারিখে কোনো ফিক্স আছে
No, 26th I have difficult.
26th I also.
আচ্ছা 25 তারিখে
I'll be out
তাহলে 3 PM আছে ফিক্স। আচ্ছা ওকে 25/6/2025 at 4 PM.
Yes.
Fine, very good. Obliged to you.
May I take back?
Yes, give your suggestions,
take
whatever you
back.
want to give.
Yes, I need a copy of the affidavit of defendant 7B.
Yes,
I
defendant
have
has
asked, no, he
yes
has not,
given you the copy of application.
no, he has not given the copy.
My lord, one thing, my lord, while my lord, the valuation and everything, my lord, he in the open court, my lord, he submitted that there is no tenant in the property.
No, that will be subject.
Give it in your written note.
Yes, yes. Let me
In a
know.
written note. Whether there are tenants or not, give it in writing.
Yes, yes.
Only
I being the receiver, I am in a better position to apprise your.
And I need a copy.
Yes, when was the last remuneration paid to the receiver?
there is a monthly tenant, monthly remuneration.
Monthly
Oh,
remuneration.
monthly remuneration. So it is being paid.
Yes, very well 60 JM. It's very nominal.
All the times, you know, this gentleman is coming and making a mess.
I need a copy of the affidavit. of
Yes, what
7B.
copy you need, you please tell him. Yes, please.
I've
give.
told him,
So that next day he doesn't come and says that.
no, no,
he
no.
requires further.
I need a copy of the affidavit of 7B. You said that 7B also wants to sell. I don't know. You had mentioned orally in the court and the court
no, I am-
directed you to give a copy.
Whatever application is being heard in court, that copy has been served upon you.
Orders, item number 11.
Hey, obliged to you, sir.
This is the application, your lordship.
Okay, this today is fixed for orders.
Lordship had said that the draft agreement we will
Anyway,
submit.
just a minute. I've GA 18.
Yes.
Yes, upon hearing the learned advocate and upon perusing the scheme friend for administering the estate, Babulal Agarwala, and considering the age of the subject premises and the present condition and the difficulties faced to repair the subject premises, this court is of the view that the petitioner's applicants have been able to make out a case for grant of permission to give lease of subject premises. Thus, the petition should be allowed. Let there be an order in terms of Tier A of notice of motion dated 3rd day of January 2025, fixed 2/7/2025 for filing draft agreement of lease.
Obliged.
Item number 12.
This is my application for grant of probate. It is a non-contentious case, my lord. All formalities have been complied with. And the attesting witnesses have duly proved the will.
Yes. Hence, the petitioner executor has been able to make out a case for grant of probate. Thus, there will be an order in terms of prayer C of the petition. Thus, probate with copy of last will and testament of deceased Sri Shailendranath Bose alias Sri Shailendranath Basu, dated 10th June 2002, be granted to the petitioner with effect throughout the state of West Bengal. The
Well, only-
department to issue probate upon payment of requisite court fees.
No, only one line, my lord. Let the department directly not to drawn up the order, my lord. It will take much time to get the order, my lord. Not
Yes, issue probate upon payment of requisite. No, you have to draw up and complete the order.
drawn up is not required in case of non-contentious case.
Let the department take steps to draw up and complete the order.
No, not to drawn up the order, it will suffice me, my lord.
Yes?
Not to drawn up the order will help me, my lord, because it will take much time. There is no.
No, usual procedure be followed. Okay. Let it be drawn.
Great, my lord.
এটা কোর্টের চেম্বারে চলে যাবে। ফাইলে ঢুকিয়ে দেবো নাকি আগের যে দুটো হলো।
আমার নয়। এই তো
লিখে দাও না, লিখে দিয়ে দাও। লাগবে না, ঠিক আছে। চলো এবার এফিডেভিটটা করি।
বাসুকে বলো, বাসুকে
আপনি কি খুলতে পেরেছেন? আপনি ল্যাপটপ থেকে ট্রাই করুন। ল্যাপটপ থেকে করছেন তো এখানে সার্ভার ডাউন আছে বলছে সকাল থেকেই সার্ভার ডাউন আছে, যার জন্য ওটা ঠিক আছে। ঠিক আছে স্যার।
Yes, my lord. Yes. My lord, it is a matter, my lord, hearing matter. Hearing any, this is a part heard matter. No, my lord, it is a hearing matter. No, hearing, is it part heard? Part heard, my lord. No, by your lordship. No, how many days did I hear this matter? My lord, anyway, let it appear as to be mentioned. To be mentioned.
May I be permitted to mention what matter, Lordship? In the back,
Order
which
to Lordship.
was grant bail in this POCSO matter, Lordship. There were two accused persons in this POCSO matter. One of them preferred an application for bail. Your Lordship was pleased to grant bail. Now the predicament is that when the accused person is going to give the bail bond, his name is not mentioned in the order.
So you want to, have you filed any application?
After your Lordship.
So let,
Your Lordship
okay,
filed
let it appear on Tuesday
you mentioned.
Lordship,
or by application.
Lordship, may I be permitted to mention virtually one matter, Lordship? In the
Just-
morning, obliged.
A copy of the state advocate. Let it appear on Tuesday.
At the top, Lordship, your Lordship.
Tuesday at 2 p.m.
My lord, similar, my lord, there was a bail order granted by your lordship in vacation. My lord, there is one correction is required only. My lord,
Correction regarding what correction?
My lord, it has been recorded that there were total 23 witnesses, out of which 4 have already been examined. My lord, instead of 4, it will be 1. Only 1 have been examined.
Anyway, have you served notice upon the
My lord, I will inform, my lord. This is only for correction only.
whatever it is, the
I
state
shall
advocate
inform,
should
my
know
lord,
that.
for this state.
Okay, to be mentioned on Tuesday.
We mention on Tuesday.
Lordship, may I be permitted to mention one matter, Lordship, virtually, Lordship? Lordship, in the morning, you can recall, Lordship, I had submitted the mentioning slip with the contempt application, but the difficulty and urgency is, Lordship, on the next Wednesday, 18th of June, learned trial court is proceeding with the matter. Date is fixed, Lordship. Prior to that, Lordship, matter to be heard by your Lordship.
When was the order passed by me? When
Yes,
was
Lordship, order was passed by you, your Lordship, Lordship.
Yes.
The order was to grant adjournment during pendency of the revisional application before this honorable court. But
No.
the learned court below,
when was the order passed?
order was passed on 18th of October 2024, Lordship.
Okay, you see, there is no such urgency in contempt application. Okay, you just file it, let it appear.
I have filed, Lordship, but Lordship,
Let it appear in.
kindly, Lordship, the difficulty is when the matter was admitted by your Lordship, that was at appearance state. Now it is evidence, Lordship. Evidence state. Case is proceeding.
I cannot alter the position. At present, I cannot pass any order of stay. You want any interim relief, you move the regular bench. Regarding your contempt, I shall see whether contempt lies or not. Let it appear in the usual course.
Obliged, Lordship. Grateful.
Oh. out of list করতে হবে আর কি হ্যাঁ কি আইটেম নাম্বারটা আচ্ছা জায়গায় নট ফুটে করে দিলেই মিটে গেল হ্যাঁ
Number 1.
Hence, this application under Article 227 of the Constitution of India stands allowed. Order dated 12/9/2023, passed by Learned Civil Judge Junior Division, 4th Court at Howrah in Miss Case number 4 of 2022, in connection with title execution number 9 of 2006 is set aside. The matter is remitted to the Learned Executing Court to decide the case in accordance with law upon in pleading the legal heirs of the deceased decree holder. It is hereby made clear that as the petitioner Vishwajit Ghosh has claimed himself to be the son of the decree holder Prafullo Ghosh and also have claimed interest in suit property, the petitioner will be at liberty to make necessary application before the learned executing court for impleading him as a party, which shall be considered by the learned court in accordance with law and in terms of the power conferred under subsection 3 of section 47 of the Code of Civil Procedure. In the event learned court is of the view that the petitioner is not the representative of the decree holder, steps shall be taken by judgment data to ascertain the names of legal heirs and implead them. However, if the learned court comes to the finding that there are no legal heirs of the deceased decree holder and the estate of the deceased has vested with the state, necessary orders shall be passed to appoint such officers to represent the suit property. It is, however, made clear that this court has not gone into the merits of the application under section 47 CPC and all points are kept open.
Number 2.
This is my Item 2, my lord. This is my civil revisional application. Okay.
Okay, let it appear on Tuesday, or I can do, it can be done one thing, it can appear on next Friday also.
Next Friday, my lord. My affidavit of service, my lord. May I file, my lord? Oh, the file is not here, possibly.
So you are representing?
The petitioner, my lord.
Okay.
Here, my lord, there was an...
Service is complete?
Yes, yes. In terms of the earlier direction, service is complete.
This is a wrong, acha, CO 572. CRR 572 হবে. Acha, let this matter go out of the list. Regarding CRR, you give the slip, it will appear on...
CRR, we are not appearing in the CRR, my lord.
No, no,
Sir, I am I am the complainant for CRR 572.
Because
okay,
it
no.
appeared as
This is CO.
Yes, CO 572, Sri Manish Kumar Sharma versus...
No, this matter was mentioned earlier by you.
No, my lord.
So this court does not have any determination.
We also thought so, my lord. That's why it is appearing today.
This bench does not have any determination.
Let it, my lord, go out.
Because it is it is not a part-heard matter.
Not a part-heard matter.
Okay, item 2, record an order.
Sir, I am complaining for the case.
Item 2, let it go out of the list.
Great.
So CRR, the matter is not appearing.
Sir, I am the complainant for the
No, CRR ought to be listed, but it is not appearing. You give the slip, it will appear next Friday.
Okay.
To be mentioned.
Revisional application সেটা appear সেটাই হচ্ছে
Next Friday হবে আমরা
আপনি স্লিপটা দিন
হ্যাঁ
আচ্ছা
देंगे तब तो
Okay, it will appear on Tuesday.
I should come on Tuesday. Thank you, sir. Sir, slip देना. Thank you, sir. Thank you.
Number 3.
Milord, I am for the petitioner. ওটা দরকার না, ওটা তো ফাইল নেই, জাস্ট মানে not today থাক, ওটা লিস্টেড আর দেবেন না. Yes, item 3.
I am for the petitioner. It's my written notes of argument.
Milord, kindly direct them, Milord, to supply us a copy of the notes of argument.
Oh, you have filed your written notes?
Sir, next week I will.
It is my written notes of argument.
Achha, record an order. Learned advocate for the petitioner is present and files his written notes of arguments. Stop. Learned advocate for the opposite parties prays for time to submit written notes of arguments. Let this matter appear on 20/6/2025 for filing written notes of arguments by the opposite party. Under the heading to be mentioned.
My lord, can kindly add one line that he has supplied me a copy of his written.
Okay, copy of the written notes of arguments is already supplied by the learned advocate for the petitioner upon the opposite party.
Learned advocate for the opposite party by the petitioner.
No, served by the learned advocate for the petitioner upon the opposite party.
Yes. Item number 4.
Lordship, I appear for the
Sanjeev Kumar.
this matter.
We're appearing. The to be mentioned, let a date be fixed.
Lordship,
This has been partly heard that there's already an interim order which is valid for 2 months.
Is an assigned matter?
No, it's a part-heard matter.
Part-heard matter.
Assigned
No, no,
as
when
well
did
as-
I make it part-heard?
Not part.
No, no. First of all, whether it is an assigned matter or not.
Assigned.
If it is an assigned matter, it need not be part-heard. No, no, let me see whether it is, first of all, whether it is, yes, you are appearing for?
For the opposite party, my lord.
No, is it an assigned matter?
Assigned matter.
So let it appear for hearing. Yes, record an order.
But the interim order also.
Learned advocates for the parties are present. Let this matter appear on 27/6/2025 for hearing. At the top, interim order granted earlier stands extended for a period of 6 weeks or till further orders, whichever is earlier.
Assigned matter.
No.
What happened? I'm for the petition.
So this is the matter where LCR was called for.
Yes, my lord.
When was your application filed for appointment of commissioner?
My lord, application, my lord, is dated.
So the impugned order is 30th of May 2023.
Yes, my lord.
30th of May 2023.
23. बाबा कोर्ट डेट तो नहीं होगा एप्लीकेशन पे now stand 17.
I believe it is 5th May 2015.
Key 5th May 2015. Key application filed by itself. No, my lord, that is perhaps the first application. The second application
5th May 2015.
16th February 2017.
16th
February 2017. তাই তো সেটা ক্যান্সেল হয়েছে কে বললো that is my order sheet এ লেখা আছে কোথাও দাও তো দেখ
Yes, 16th February 2017. Here is the copy you have a copy of this application. No, this
Well, our-
commission application for commissioner.
Yes, yes, annexed with our affidavit in opposition.
So question is, let us see the writ.
Proceeding. कोई एक्टर प्रियंका नहीं है চলে গেছে রেকর্ডে দেখা যাচ্ছে আমার চলে গেছে মানে ডিটেল হচ্ছে প্রিন্সিপাল নাম
The order is as 19/7/2019 is the Learned Advocate Commissioner is directed to make inspection work according to the points mentioned in the petition for local inspection dated 29/3/2019 in order to look after the cementing work. This is the order dated 19/7/2019.
Yes.
That is a different. That is a different one. There was one for local commission, one for repairing work. I
No,
believe this.
19/7, no. Here it is order dated 29/3/2019.
Well, that is perhaps subsequently. There was an order for cementing the suit premises for doing some repair work. That is that application under 151, I believe. 151 and
One was the local
Here
investigation,
we are
another
concerned
was
with
local
this local inspection dated 29/3/2019.
This is order 39 rule 7.
Yes, order that is order 29/3/2019.
No, my lord, the order for local inspection was passed in 22nd August 2017. 22nd August 2017. That is the investigation.
2nd August 2017.
17.
Yes, no, this was under order 26, rule 9.
Yes. My lord, kindly see the ordered portion, second paragraph. Sri Tanmay Mojumdar is for appointed for commissioner work.
To suit property schedule of the plaintiff as per the point mentioned in the
petition dated 16th February 2017. The petition which my lord just saw. This is the first order. Then acceptance order has been challenged.
16/2/2017.
17. This is our application.
So there was a direction to issue writ also.
Yes. But as per the orders, writ was submitted.
And you are directed to submit the settlement map RS.
Yes.
Yes. So what was the prayer in 16/2/2017? So it is annexed definitely.
Yes,
It
yes.
it is in affidavit in opposition. Annex, my lord, page
12.
12.
Affidavit in
Opposition, page 12.
Yes. Yes. So these were the points for local investigation.
Yes.
So what is your grievance with regard to the commission work? As per the direction, the commissioner was required to cause necessary investigation as per the points mentioned in petition 16/2017.
Yes.
So what is your grievance with regard to the investigation work?
Yes. Kindly, my lord, comes to the order dated 22nd August 2017, annexed with the affidavit in opposition.
Page 16, my lord.
Yes. So this is the order.
Yes.
26 appointing that is 22/8/2017.
Yes.
This is the order
Yes, yes, yes.
by which the commissioner was appointed to conduct the investigation. So that was conducted, and the commissioner was required to conduct investigation with regard to the points for local investigation
And to file a report.
Yes, as per the petition. So what is your grievance with regard to the investigation work?
Yes. Kindly comes to my lord, page 17.
Yes.
And you see, let such and such learned advocate is appointed as investigation getting advocate commissioner for conducting the local investigation commission in this wood property mentioned in the schedule of the plaint. This is important, and as per the points mentioned in the petition dated 16th February 2017, to in order to bring the clear picture in regard with regard to the suit property before this court. Well, this was the direction.
Yes.
Therefore, my lord, the points here to consider, my lord, considering the plaint and the application dated 16th February 2017. This was the clear direction. My lord, kindly see, my lord, let us see, my lord, whether this has been complied with at all. The revisional application. Now, my lord, kindly takes up the plaint. What is the case made out in the, my lord, plaint?
Plaint is annexed.
Yes, my lord, with the revisional application, page 9. My lord will kindly comes to page 10, para 1 and 2.
Page 10. Page 10, that is annexure 1.
Yes.
Annexure R1.
No, A. Revisional application. Annexure A.
Annexure A. Yes, page 10. Yes.
Kindly see me, what is the case made out in the plaint? অত্র আদালতের এলাকাধীন কাটোয়া মৌজা সীমানার মধ্যে নিম্ন তফসিল বর্ণিত সম্পত্তি সমূহ অবস্থিত হইতেছে। পূর্বে নিম্নের ক তফসিল বর্ণিত সম্পত্তির মালিক ও দখলিকার বাদিনীর মাতা অধুনামৃতা উমা রায় ছিলেন এবং তাহার মৃত্যুর পর তাহার একমাত্র ওয়ারিশ কন্যা স্বরূপে বাদিনী নিম্নের ক তফসিল বর্ণিত সম্পত্তির মালিক ও দখলিকার হয়েছেন ও উক্ত সম্পত্তির হালচলিত এলার সেটেলমেন্ট রেকর্ডে তাহার নাম যথাযথভাবে রেকর্ড হইয়াছে। নিম্ন ক তফসিল বর্ণিত সম্পত্তি একটি দ্বিতল বাটি হইতেছে ও উক্ত বাটি উত্তর দক্ষিণে দৈর্ঘ্যের বিশিষ্ট ও পূর্ব পশ্চিমে প্রস্থ বিশিষ্ট হইতেছে। উক্ত বাটিতে প্রত্যেক তলার অনেকগুলি করিয়া ঘর রইয়াছে এবং এই ঘরগুলি পূর্ব দেওয়ালে ও পশ্চিম দেওয়ালে জানলা রইয়াছে। উক্ত বাস্তুটি ইংরেজি 1956 সালে পূর্বেই নির্মিত হইয়াছে। এই বাস্তুটি নির্মাণের সময় নিয়ম মতো জমি রায় নিয়ম মতো উমা রায় চতুর্দিকে বিশেষ করিয়া পশ্চিম দিকে 3 ফুট প্রশস্ত বিশিষ্ট জায়গা ছাড়িয়া রাখেন। উক্ত জায়গা নিম্নের ক এক তফসিলে বর্ণিত হইল। Therefore, what is the case? Q topshil is the house and the vacant portion is the Q1 topshil. That is the case made out. Kindly see paragraph 2. নিম্নের ক তফসিল বর্ণিত বাস্তুবাটি পশ্চিম দিকে নিম্নের
No, this is the facts of this is the case of the plaintiff. Now the question is, what was the commissioner required to do? That is,
Miller, for that
Yes.
plaint is required to be seen.
Yes.
Paragraph 2 is required to be seen. Because that cannot be independent of the plaint. নিম্নের ক তফসিল বর্ণিত বাস্তুবাটি পশ্চিম দিকে নিম্নের খ ও গ তফসিল বর্ণিত বাস্তুবাটি অবস্থিত হয়েছে। বাদিনীর যতদূর অবগত হয়েছেন তাহাতে 1 নম্বর বিবাদী নিম্নের খ তফসিলে বর্ণিত সম্পত্তি তলি জায়গায় ইংরেজির 1992 সালে খরিদ করেন এবং তৎপর তাহা গৃহাদি নির্মাণ করেন। 2 নম্বর বিবাদী এই একই সময় নিম্নের গ তফসিল বর্ণিত জায়গায় খরিদ করিয়া উহাতে গৃহাদি নির্মাণ করেন। বাদিনীর মাতা কাটোয়া স্টেট হসপিটালের নার্স ছিলেন এবং তাহার স্বামী বহু পূর্বে পরলোক গমন করেন এবং তাহার কোনো পুত্র সন্তান ছিল না। বিবাদী নিম্নের খ ও গ তফসিল বর্ণিত সম্পত্তিতে পূর্বোক্ত মতে গৃহাদি নির্মাণ করিবার সময় পূর্ব দিকে অতি সামান্য জায়গা ছাড়িয়া রাখেন। বাদিনীর মাতা অজ্ঞাত হওয়ায় এই ব্যাপারে যথাযথ দেখাশুনো করতে পারেন না ও বিবাদী উক্ত কার্যে প্রতিবাদ করতে পারেন নাই। বিবাদীগণ সম্পূর্ণ অন্যায় ও বেআইনি মতে নিম্নের ক তফসিল বর্ণিত সম্পত্তিতে মিথ্যা দাবি উত্থাপন করিতেছেন। নিম্নের ক দুই তফসিল বর্ণিত সম্পত্তি নিম্নের ক তফসিল সম্পত্তির শামিল ও উহার দক্ষিণাংশ হইতেছে। Therefore, ক এক তফসিল is the vacant portion and according to them, ক দুই তফসিল is the encroached area by us. This is the case made out. ইংরেজির 1 নম্বর বিবাদী সম্পূর্ণ অন্যায় ও বেআইনি মতে ইংরেজির 29/4/2015 তারিখে সকাল হইতে নিম্নের ক এক তফসিলে বর্ণিত সম্পত্তি একেবারে শেষ প্রান্তে অর্থাৎ নিম্নের ক তফসিল বর্ণিত সম্পত্তি স্থিত বাস্তুবাটির পশ্চিম দেওয়াল লাগাও প্রাচীর গাঁথিতে শুরু করেন এবং তাহার উক্ত রূপ কার্যের ফলে ক তফসিল বর্ণিত বাস্তুবাটির নিচের তলার পশ্চিমাংশের দেয়াল অবস্থিত জানলার কিয়দংশ ব্লক হয়ে যায়। Therefore, construction on Q1 topsil and the ক তফসিল the window of ক তফসিল is blocked. Now partially বাদী তাহার উক্ত রূপ কার্যের প্রতিবাদ করিলে তাহাকে এই কার্য হইতে বিরত থাকিতে বলিলে কিন্তু কিন্তু তাহা কর্ণপাত করে, those are the cause of action. Now my lord, therefore the what is the my lord case? Co1 and co2. Co1 is the my lord entire building, co1 is the my lord vacant area, and co2 according to them alleged is the my lord the encroached area, which forms part of co1. Now my lord, kindly see my lord the schedule at page 13.
Page 13.
Yes my lord.
Yes.
Kindly see my lord, Topshil Ko. What comprises of Topshil Ko? Jela Bardhaman such and such, Hotian number 13396, Dag number. They are proceeding with their case as CS plot number 404. LR plot number 404/994. 3 শতক ও 404/6499 ও 4 শতক 404/6531 ও 1 শতক, মোট পরিমাণ 8 শতক। Therefore all total my lord, the area is 8 শতক, comprising of mainly CS dag number 404, which has been according to them LR subsequently my lord it has gone as Bata dag LR number such and such, and subsequent LR Bata dag 404/6499.
Oh, this is Toposhil Ko is entirely the entire shoot property.
No, Topshil Ko is my lord the building.
Toposhil Ko1, that is A1, it is the vacant land.
Yes. Now my lord, kindly see my lord the
that is Co2 is the encroached portion.
Co2 is the according to them is
of the land.
Exactly.
Yes.
Therefore
And there is another Toposhil Kogo that is not
relevant for the purpose of this case. Yes. Therefore
that does not belong to either of the parties, Toposhil Kho and Go.
Let me see my lord the pleading my lord what they have said. Or Gota কি বলেছে? Now kindly see my lord paragraph 2 of the plaint my lord. Page 10 para 2.
Yes, page
the last 3 lines from the bottom. It starts with the word বিবাদীগণের নিম্নের খ ও গ তফসিল সম্পত্তিতে পূর্বোক্ত মতে গৃহাদি নির্মাণ করিবার সময় পূর্ব দিকে অতি সামান্য জায়গা ছাড়িয়ে রাখেন। my lord, this is not relevant. That is my lord plaintiffs, they have left land for construction. Encroached portion is Co2, which is part of Co1.
Okay. So that is there. So this is the O1. No, the direction of the learned trial court is this investigation to be
according to the plaint and the mentioned in
plaint means schedule of the plaint.
Exactly, schedule
of the plaint and the points which are raised in the application. So where is the deviation by the commissioner?
Now my lord, kindly comes to the application. At page 20. No, it's a report. Application my lord is annexed in the affidavit in opposition. Kindly takes up the affidavit in opposition my lord, application is annexed. At page 12.
Yes.
Kindly see my lord. Points of local investigation. Katwa Moja CS O RS map relay করতো আরজির ক খ ও গ তফসিল বর্ণিত সম্পত্তি সমূহ অবস্থান এটা কি স্কেল ড্রোন ম্যাপে দেখাইতে হইবে। 2 আরজি ক ও ক ও কয় 2 তফসিলে বর্ণিত সম্পত্তি সমূহে প্রত্যেকটি দৈর্ঘ্য ও প্রস্থ কত বলিতে হইবে ও এই 2 তফসিল বর্ণিত সম্পত্তিতে সমূহের অবস্থান স্কেল ড্রোন ম্যাপে দেখাতে হইবে। নেক্সট আরজির ক এক তফসিল ও ক দুই তফসিল সম্পত্তি ক তফসিল বর্ণিত সম্পত্তি শামিল ও একাংশ কিনা বলিতে হইবে, মানে ভার্চুয়ালি রিপিটেশন অফ পয়েন্ট নাম্বার 2। নেক্সট, আরজির ক তফসিল বর্ণিত সম্পত্তি তরফে যে গৃহাদি রইয়াছে তাহার একতলে পশ্চিম দিকে 3টি জানলা রইয়াছে কিনা এবং একটি জানলার বেশ কিছু অংশ আরজির ক এক ও ক দুই তফসিল বর্ণিত স্থানে সম্পত্তি দেওয়াল নির্মাণে ব্লকড হইয়া গিয়াছে কিনা এবং এই 3টি জানলার ব্লকড হইয়া যাওয়ার পোর্শনের দৈর্ঘ্য প্রস্থ উল্লেখ করিতে হইবে। নেক্সট, পূর্বোক্ত ক এক ও ক তফসিল বর্ণিত স্থানে বা সম্পত্তিতে নির্মিত প্রাচীরের কন্টিনিউয়েশনে দক্ষিণ দিকে একটি পাকা ড্রেন রইয়াছে কিনা এবং এই ড্রেন, দিস ইজ নট রেলেভেন্ট ফর মিলর্ড এনক্রোচমেন্ট। দেন মিলর্ড কাইন্ডলি সি 6, আরজির তফসিল বর্ণিত সম্পত্তি যে পূর্ব তরফে একটি অসম্পূর্ণ পাকা ড্রেন আছে কিনা তা স্কেল থাকিলে তাহার দৈর্ঘ্য প্রস্থ গভীরতা উল্লেখ such and such. Milord, those are not related to encroachment. Therefore, point number 1, 2, 3 is similar to 2 and 4, Milord, is the relevant point.
1, 2, 3,
4.
4. Anyway, the direction is entire.
Direction is entire. Now, Milord, the order, Milord, Lordship has already seen 22nd August. Milord, one advocate inspection commissioner was appointed, Milord, for conducting inspection into the suit property on the mentioned in the schedule of the plate as far as the points mentioned in the petitioner of local investigation. Now, Milord, kindly sees the report. At page 20 of the revisional application. Milord has got it, Milord.
Page 20.
Yes, Annexure C.
Yes.
But may I just point out one thing? The whole report has not been annexed in the revisional application. The maps and everything has been annexed in the affidavit in opposition. Here, he has only annexed the reports. The maps and all the scale run maps, they are in
Affidavit in opposition.
Very, let him show from his revision. I don't have.
Yes.
Yes. Now, Milord, kindly see the Milord, third paragraph.
Yes.
Before starting my actual survey work, I searched for fixed points or permanent landmarks for the purpose of relaying, and finally I took the points of my good satisfaction in the northwest corner of plot number 903, in southeast corner of plot number 405, and northeast corner of 986 in a little distance from the suit plots as fixed points or permanent landmarks of relaying. First, Milord, are these, Milord, CS plot number, RS plot number, or LS plot number? How do we identify those fixed points? How do we identify those fixed points?
That is there in the extended report.
What was
I'll show to your Lordship what is
what
there.
was the direction? That is
Plaint and points mentioned in the Milord application. Plaint, there is no RS record.
no.
They say CS and LR Bata. There is no RS. That's why I was repeatedly placing cost schedule of the plaint.
No, if corresponding RS is required to be found,
I'll show that is
that has to be done.
Yes, I'll show his cross examination. He has said that none of the parties has supplied it to me. I'll show it from the cross examination.
Okay, now what is this search for fixed points?
Yes. Now, my lord, the where he has put the fixed points because because RS record kindly, my lord, once my lord kindly sees comes back to the schedule of the plaint to so that we can compare at page 13 Court of Shield.
Page 13, yes.
Now, my lord, kindly see what is the case, how they are proceeding. They are proceeding as the entire Court of Shield as, my lord, second line, dag number CS 404. They are proceeding as on the basis of CS, which they say this is corresponding to LR 404 by 994 Bata. And also 404 by 6499. And also 4044 by 6531. Therefore, they are proceeding on the basis that CS was divided into 3 Bata dag. Initial CS record was LR dag number was 404.
Yes.
What?
Yes, 404
was the original dag number.
Yes.
Therefore, my lord, RS record came after Estate Acquisition Act, then my lord LR after Land Reforms Act, my lord Cadastral Survey, then my lord LR record has come. In LR, they say, my lord, there are 3, my lord, it has been divided into 3 Bata dags.
No, the dag numbers are subdivided.
That is Bata. That is Bata dag.
That means originally it was this.
Yes, original dag number is, my lord, 404.
I'll just clarify one point. We have submitted the additional documents. Original CS dag was 404. From there, LR Bata dag. LR Bata dag changed into exact same mirror image. RS Bata dag was changed into exact same mirror image LR Bata dag. There was no change of the total land area or even the numbers. We have submitted both the RS Porcha and the LR Porcha as an additional document.
Yes. So far your plaint
Before-
is concerned, it was CS
Submitted
and LR.
before whom?
Before my lord?
Before my lord, not before the commissioner. This court, my lord, did not conduct the commission.
Anyway, so according to you, this is the usual procedure. From CS, it will go to RS and thereafter LR.
Yes. But here the RS and LR were exactly same. There was no change.
Those were not part of the records before the trial court. This has been first time, my lord, come up
Anyway,
before your
then.
lordship. Now, my lord, let me proceed. Now, my lord, as I was placing, my lord, page 20. Kindly see what I was placing. He took fixed points from plot number 903 in southeast corner of plot number 405 and northeast corner of plot number 986 in a distance from the suit plot. Therefore, he doesn't mention whether, my lord, this is CS record was superimposed with RS. These are, my lord, the settled principles of investigation, or which was superimposed with LR. Therefore, which are these plots from which he has taken, my lord, fixed points? My lord, that is not clear. Then my lord, let me proceed. Then I selected survey station connecting the suit plot.
Yes, which paragraph you are reading?
My lord, page 20, my lord.
Page 20.
Yes, my lord.
Yes.
The third paragraph.
Yes.
Before starting my actual survey work, I searched for fixed points or permanent landmarks for the purpose of relaying, and finally, I took the points for my good satisfaction in northwest corner of plot number 903, in southeast corner of plot number 405, in the northeast corner of plot number 986, as a little distance from the suit plots as the fixed points of or permanent landmarks for relaying. Then I selected survey station connecting the suit plot and the fixed points or of the permanent landmarks. I took fixed points, points save and accept the above mentioned fixed point, which is only noted in the field book paper. Then finally, I took the fixed points after proper checking and verification, verified plot number 1027, again a vague one. Again a vague one.
Plot number 1027.
Again a vague one.
No, from which place? No. Is it under the schedule?
No.
Well, that is a verified plot. One plot has to be verified. From there, the chain has to be, measurement has to be done. He has not challenged that this verified during while taking the commission or before the trial court. He has not challenged that this verified plot was wrong. Let us say, my lord, this court has to be measured. So what the commissioner does, he comes and takes Raj Bhavan as the first point, fixed point. Here 1027 is a fixed point. He has not challenged it before the commissioner or even before the trial court, saying that the fixed point was wrong. So that finding of fact is there. He cannot now say that it has been wrong. The Lionel trial court has held that fixed points were good, no issues. So from there he has made the measurements. So the fixing of the fixed points cannot be challenged right now. He had to challenge it before the commissioner. Even in his objection before while acceptance, the points have been specifically noted. What were these objections to this commissioner report? Nowhere it was said.
Regarding the fixed points, did you submit any objection before the commissioner?
Never. Kindly seize the impugned order.
Anyway,
proceed,
just-
Millard. Let me proceed, Millard. With more verified plot number 1027 with my good satisfaction of my local investigation for my fixed point or permanent landmarks on marks on the concerned Mouja. I started my survey work from northwest corner, that is station 1 by direction with anti-clockwise. I took some tie lines in my said investigation of the above suit, which is known as the which is shown in my hand sketch map and the case map. The hand sketch map is part of the field book of my report. During my survey work of the offset measurement of the field points of the permanent landmarks of the suit plot on the other side of my chain line and noted them in my field book. Then Millard yes, kindly comes. After completion, the field book, I returned the same with the field book plotted to its scale of such and such and traced it to place of a tracing cloth and thus obtained the case map. The next Millard is important. Then I enlarged the corresponding portion of suit plot as per RS map in the same scale and superposed it over present survey map in which in such way the aforesaid points of permanent landmarks and point may exactly coincide. As there is no technical defect in my local investigation, my report preparation according to the survey regulation. Therefore, he says that he has enlarged and superimposed with RS map. Millard, this is his statement. Now, Millard, kindly see the next page. This is, Millard, very interesting. Kindly, Millard, takes up the next page. This is the report he has given point-wise answer, page 22. Kindly see, Millard, answer to point number 4. আরজির ক তফসিল বর্ণিত সম্পত্তি উত্তর পশ্চিম তরফে যে গৃহাদি পাকা দোতলা রহিয়াছে তাহা একতলা পশ্চিম দিকে দেওয়ালে তিনটি জানলা পি কিউ ও আর রহিয়াছে এবং এই তিনটি জানলার কিছু অংশ আরজির ক এক তথা ক দুই তফসিল বর্ণিত স্থানের সম্পত্তিতে দেওয়াল বহু 3 ইঞ্চি ইটের গাঁথনি দ্বারা নির্মিত ফলে কোনটি আংশিকভাবে কোনোটি অসম্পূর্ণভাবে ব্লক হইয়াছে এবং বিশদভাবে বলা যায় যে কেস ম্যাপে পি মার্ক জানলাটি যাহার দৈর্ঘ্য 4 ফুট ও প্রস্থ 3 ফুট 7 ইঞ্চি 8 ইঞ্চি পর্যন্ত ব্লক হইয়াছে। কিউ মার্ক জানলাটি যাহার দৈর্ঘ্য 4 ফুট ও 5 ইঞ্চি ও প্রস্থ 3 ফুট 2 ফুট 5 ইঞ্চি 2.5 ইঞ্চি 5 ফুট পর্যন্ত ব্লক হইয়াছে এবং আর মার্ক জানলাটি যাহার দৈর্ঘ্য 4 ফুট 3 ফুট 3.2 ফুট পর্যন্ত ব্লক হইয়াছে। দিস ইজ অ্যাকর্ডিং টু হিম দি এনক্রোচ পোর্শন ক1. According to him is the ক1. Now my lord, but therefore this according to him is the my lord encroached portion. Now my lord kindly comes to the impugned order once. Then my lord, after placing it, my lord, I shall place the my lord cross examination of the commissioner.
Impugned order.
Yes.
Yes.
30th May 2023.
23, yes.
Kindly see, my lord. Heard both the sides, the third paragraph. Heard learned advocates of both the sides, my lord has got it, my lord.
Yes.
Then, my lord, kindly see the next paragraph. The objections against local investigation report as raised by the defendants are summarized as follows. The learned commissioner has not relayed CS settlement map in either field book or case map. The learned commissioner has not measured the total area of disputed plots either in CS settlement map or LR settlement map. Because why I say so? Because, my lord, that's why that is the, my lord, precise, my lord, my objective was to read, my lord, answer to question number 4, that handwritten, his reply. He does not give any answer to question number 4. That is his own handwritten report. The notations in the case map was filed by the learned advocate commissioner do not mention the disputed property, which in turn renders the report incomplete. The learned commissioner has taken plot number 1027 as a verified plot. However, it cannot be found that there is no such permanent landmark in plot number 1027. On the contrary, there are permanent landmarks in plot number 580 and 581. However, the same have not been taken as fixed point. As such, the selection of fixed points by the learned commissioner is erroneous. Therefore, I raised points regarding objection regarding fixed points.
Yes, actually, you see, 227 jurisdiction is only to see supervisory jurisdiction if the order is perverse or points not taken into consideration.
Coming to that, this is
a limited jurisdiction.
Yes, this is perverse. Coming to that, this is perverse. If this is not perverse, my lord, I'll show to your lordship. It is pertinent here to mention at the outset that the advocate commissioner is presumed to be an expert in his work field, and the court should not interfere with the laborious work of an advocate commissioner unless there is gross miscarriage of work or the integrity of the commissioner is at stake. The learned commissioner has relayed RA's settlement map to prepare the field book and case map. There is no mandate to follow a map prepared during particular settlement operation only to carry out the commission work. The learned commissioner during his evidence has affirmed to have conducted the commission work consulting in RS settlement map. The report also attributes the same. Also, there is no ground to reject the report merely due to the fact the CS settlement map was not consulted by the learned commissioner during the commission work. The learned trial judge is, my lord, going against its own order allowing the commission. Kindly recalls it once. What did, my lord, the 22nd August say? It said that the Tanmoy Chowdhury, learned advocate investigation commissioner, shall carry on the investigation work in terms of the schedule of the plaintiff and with the points taken in the RS map. Now, Milord, I have shown Milord the schedule of the plaintiff. The schedule of the plaintiff was CS, and I will show from the Milord the cross-examination of the commissioner and recorded in the order that CS map itself was not consulted. What was consulted was the RS map, and where from this RS map has come the recording, this RS, they have made a stray statement in the points of local investigation. Once kindly see that application, which is Milord annexed Milord in the affidavit in opposition. Page 12.
Page 12, yes.
Now, Milord, kindly see first Katua Moujai CS O RS map relay karo to. Here, Milord, this is the only stray, Milord, what they have used RS map, RS record relay karo to. Now, Milord, in the schedule, cost schedule of the plaintiff, they say CS, original CS was 404. Thereafter, in LR, 3 Milord Bata dags were created. What is the Milord corresponding to RS? Nothing is there in their own pleading.
According to them, they have submitted that, yes.
Here, before your lordship, before your lordship, before your lordship. And the learned trial court has recorded non-measuring of the non-relaying of the CS dag, which is their parent claim in their plaint. According to the CS dag, they are proceeding in their plaint is not fatal to the Milord Investigation Commission report. Milord, if this is not perversity, Milord, subject to correct consideration by your lordship, Milord, there cannot be none other thing called perversity. Then, Milord, let me proceed with the impugned order again. Regarding the measurement of total area, plot number 404, it can be found that the writ of commission, the learned commissioner was not directed to measure.
Yes, which paragraph you are reading? Report states, further states.
The second paragraph at second page, Milord, regarding measurement.
Yes, regarding the measurement.
First paragraph, Milord. May I place it again, Milord?
No, first paragraph. Yes, first paragraph is this objections taken by you.
Exactly. And
yes.
Then, Milord, he has dealt with. Kindly see the last paragraph of the first page. Last paragraph of the first page.
Yes, learned advocate commissioner.
Commissioner has relayed RS settlement map. What is the RS dag? Nothing there on the Milord pleading of the plaintiff. Nothing. There is a plaintiff has not pleaded. Court has, Milord, the commissioner has proceeded to deal with RS map, and court has, Milord, put a stamp on it. RS settlement map to prepare the field book and case map. There is no mandate to follow the map prepared during the particular settlement operation, only to carry out the commission work. The learned commissioner, during his evidence, has affirmed to have conducted the commission work consulting the RS settlement map. The report also attributes the same. Accordingly, there is no ground to reject the report merely due to the fact that CS settlement map was not consulted by the learned advocate commissioner during his commission work. Regarding the measurement of total area of plot number 404, it can be found from the writ of commission that the commissioner was not directed to measure the total area of plot number 404. The learned commissioner has only duly answered the points measured in the writ of commission regarding Kho and Go schedule property, as well as the Kho and Kho 1 schedule property of the suit property. Milord, this is, Milord, the second defect. Kindly, Milord, again comes back. The learned trial judge says that he was not, Milord, directed to measure the entire.
In the writ of commission, so Let us see the writ of
It
commission.
is not there in the law court record. So
No,
far
it
as
is LCR. LCR.
so far as I have checked up, my lord, I may be wrong.
It was only issued to the commissioner.
Maybe. I could not find it out. But perhaps if my learned friend may assist your lordship, my lord, I could not find it out.
Anyway,
It should have been there because the writ was returned with the case map. It should have been there, but it's
so
not.
the
there.
court department has detained it. Not
Najarat maybe.
Yes, so
The learned regarding the measurement of total plot number 40, it can be found from the writ of commission. The commission was not directed to measure the total area of the plot number 404. The learned commissioner has duly answered the points referred to in the writ of commission regarding to Kho and Go schedule property, as well as the Kho1 and Kho2 schedule property of the suit property. But Kho and Go, my lord, are totally irrelevant. Kho and Kho2, my lord, what is relevant?
no, but as per the court's order, entire thing.
But he did not measure 404. He did not measure 404. How will he measure?
Here it is stated that writ of commissioner was not directed to measure total area as per the writ of commission.
Miller, kindly see, Miller.
Writ of commission was before the court, I think.
Yes.
So, but why it will not be in the record?
Milord, Milord, I may be wrong, Milord. I could not find it out, Milord. It may be there, Milord.
It is not there, my lord. We have seen.
This is the observation of the court.
Yes.
That he was not required to measure.
Yes.
The total area of plot number 404.
Then, Milord, kindly see point number 1 of the local investigation.
But 404 is the total dag. I don't think Kho and Go makes up the total 404. That is why he has said total 404 was not required, because the plaint case is for a portion of 404. That is the 3 bata portion.
No, from total measurement he will arrive at the disputed portion.
Yes.
From total and thereafter the disputed portion, then
what is the extent of his claim cannot be measured unless 404 is, and
from the entire property, the encroached property.
And 404 cannot be measured by him. Why? Because previous paragraph says the learned trial judge says that the learned commissioner has not measured 40 is not required to measure 404.
404 is about vacant land.
No. 404 is the total dag.
Total.
Kho and Go forms a part of the 404. Now, let us say 25% of the land is Kho Go. That is the total land areas which is considered under the suit, and the dispute is regarding only Kho and Go. So, if that total 25% is totally demarcated, if that portion is seen, then only the total would come out, because what has been said in the plaint is that Kho is my portion, Kho and Go are the portions of the defendant. They have come in at Kho1 and Kho2. The question was whether
that is the encroached portion.
That is the encroached portion.
So
whether
the measurement of entire Kho
and Go should have been done. Kho includes Kho1 and Kho2.
Yes, Kho includes Kho1
and whether the question was
404 is what?
404
plaintiff and defendant.
No. 404 is total. There are other people also. Kho and Go is plaintiff and defendant. The question was whether Kho1 and Kho2.
But it falls within 404.
It falls within 404.
So 404 is a vast area.
Vast area.
From that, your portion, defendant's portion,
yes,
and the encroached portion of yours
has to be seen. That he has seen.
Yes, that he has seen, Milord. Kindly see, Milord, Kotop Shield, Milord, again of the plaint.
Anyway, 2 minutes is left. You cannot conclude today. So next week, any date I'm fixing it, you file your written notes and give him a copy, so that on the next date, if you conclude, I think you don't have much to submit. Give your written notes of arguments on the next date.
No, Milord, 2 or 3 points, Milord, I'll submit and then give.
So
I'll try to prepare it, Milord.
So you want to conclude the next date?
3:30 today.
3:30 today. So I'm keeping it either Thursday or something, because in Friday so many matters cannot be taken up.
Friday, Milord.
This is the difficulty because other matters are also to be taken up.
Friday, let it be on Friday. Let it be.
So Thursday, you have any difficulty?
Lord,
Wednesday? Huh?
Well,
Tuesday? আচ্ছা টিউসডে আবার অরিজিনাল সাইটের কেউ নেই তো আমার ওই ফিক্স ম্যাটার কি আছে আমি ঠিক বুঝতে
অরিজিনাল
পারছি না।
সাইটের মধ্যে লক্ষ্য
Tuesday
রাখা খুব মুশকিল। ও কেউ
কেউ
কখন
নেই না?
ডেকে দেবে? Let it be on Friday.
Just a minute.
মাগো, বিশ্বাস করে না।
মঙ্গলবারে 2 PM ফিক্স আছে বোধহয় কিছু। Because you see, if it is not completed on Tuesday, he will take some time, he will give the reply, it will go to Friday.
Let it be on Thursday. On Friday.
Friday, there are some other matters also, it will not reach.
Let it be the first matter.
কি মঙ্গলবারে আর দুটোর সময় যেটা আছে সেটা টু বি মেনশনড ওই জাস্ট কিছু কারেকশন আছে সেটা মঙ্গলবার 3 PM কটা আছে ফিক্সড আছে ওয়েডনেসডে মানে ওটা মঙ্গলবারে আছে আর কি ওয়েডনেসডে ইউ হ্যাভ ডিফিকাল্টি
I was praying for Friday on 2 PM.
আচ্ছা রেকর্ড অ্যান্ড অর্ডার learned advocate for the petitioner submit but could not conclude his arguments. Let this matter appear on the 20th of June 2025 for further hearing. You can come with your written notes to expedite the matter.
Very good. Very good.
So that on the next day he can consider your written notes, file the written notes and conclude.
Right.
Okay, 20th.
Before my lord rises, not items 7 and 8 are all part-heard matters. Not it should be grouped under the part-heard matters. 7 and 8 also.
7 and 8.
Yes.
So all matters are part-heard.
Item 6
These are out of that group, therefore it's going down. Let it be on the part-heard group.
All are, you see, this is coming under the category of part-heard groups. All under the part-heard. Oh, this hearing.
Yes, yes, yes. No, it should be in the part-heard group. That is what my innocuous prayer is.
Acha, item 7
and 8.
Item 7, 8.
And my told item 6 also, man, it was part.
The 6 is in the group. 6 is already.
So 6 is appearing under the part-heard. আচ্ছা 7 আর 8 টাকে part-heard এর মধ্যে দিয়ে দেবে আর 9 টাকে assigned এর মধ্যে
Item 6 may be taken up on 6th day, my lord, we are ready with the hearing of the matter because we'll recall, my lord, that Vimuttor matter, my lord, where the arguments were advanced and
so only thing is you have to reply the opposite party.
No,
one thing, my lord, constitution application business
One
there.
constitution application.
Otherwise-
Human application.
Oh, an application is pending.
No, my lord, one is died, my lord.
So you better do one thing. You file your application on Monday, let it appear on Tuesday.
And it will be disposed of on.
Let that substitution application be disposed.
Yes.
Thereafter, I shall take up the main matter.
Then main matter.
So, have you filed it or you will file it?
I have not filed it, but on Monday I will file.
If you file it on Monday, you mention it at 2 PM.
Like Monday at 2 PM.
Yes, Monday at 2 PM, so that it can be listed on Tuesday.
Or, my lord, I can hand over this slip to the.
Yes. Application usually comes. The moment you file, it will come.
Yes.
Next Tuesday, তাহলে কতটা সময় দুটোর সময় দিয়ে দেবে কারেকশন আর ওই অ্যাপ্লিকেশন দুটো অ্যাপ্লিকেশন আছে বোধহয় একটা এই অ্যাপ্লিকেশন আর আরেকটা অ্যাপ্লিকেশন যেটা মেনশন করলো না ওই তো এই সবই দুটোর সময় আর কি আর তারপর ওটা হয়ে গেলে আবার ব্যাক অরিজিনাল সাইট
দেখে নি
এই এলসিআরটা ওর সাথে থাকবে তো
public.